So now we move on to our next session, integrity and performance of administrative review in social security. I'd like to introduce to you Emeritus Professor Terry Carney from the University of Sydney Law School and Dermott Williams, community lawyer at Social Security Rights Victoria. Thank you very much, Terry and Dermott.
Thank you very much. It's a delight to participate in this conference. I'm speaking to you today from the land of the Geringer clan of the Wandjiwardian people. That's at the mouth of the Shoalhaven River, effectively, near Nara in New South Wales. And I honour leaders past, present and emerging. I've got a few points to make. I'm the sort of the warm-up speaker for a person who really knows these issues. In my co-presenter here today. So I've got some slides, and I think in a second I'll get the right to share them. I can share it now. I can see it on the screen. So let me bring those up. So with a bit of luck, people should be seeing something. And as soon as I press a little gadget here, I'll be able to make them animate themselves with a bit of luck. So hopefully, provided, Leanne, you can see the slides. I have run classes occasionally where an hour into a presentation, people say, well, I can't see your slides.
Looks good, Terry. Looks
good, excellent. All right, so our session here today, where Dermott Williams from Victoria is really the expert on the actual case example these days. As I think you know, I spent just on 40 years as a part-time legal member of first the Social Security Appeals Tribunal and then later the AAT. And so until the then government decided it didn't like my robo-debt decisions, I gather, and decided not to reappoint me. So I saw it from one side of the merits review appeals process, and Dermott sees it from the much more important side, the side of applicants and people who represent powerless, vulnerable, nervous, worried, and usually victims of significant injustice. So we're looking at the integrity and performance of the system as it currently stands. And I thought I'd open with this quote from the former Chief Justice of the High Court of Australia and the very first president of the Administrative Appeals Tribunal. He thought, and I agree with him, that this tension between the bureaucracy on the one hand and civil society and people concerned about justice, it's a serious, it's a large gulf most of the time, and a really serious tension between the two. So, you know, his quote is, bureaucracies sometimes regard the AAT as an irksome trespasser on their territory, a cuckoo in the administrative nest. And so it is. And in his respectful opinion, that's the way it should be. It should be a constructive participant in the improvement of administration and the refinement of policy. So it's very interesting, isn't it, that it's not only about justice in the individual case, critically important as that is, it is about achieving the broader systemic changes so that future injustices, if not eliminated, are at least significantly reduced. And that in a way goes to the heart of misunderstandings of lack of integrity or competence in appointment of members to the AAT that I'll be touching on in the next couple of minutes. So the next point I've brought up on this first slide, and these slides will be available to anybody who wants to get them after the session, so this second point is that the tribunal, like any human agency, is only as good as the people who do the work on that body, and that means that first of all, the people need to actually understand that your task is to step into the shoes of the administrator and make the correct and preferable decision. And you may say, well, of course, everybody ought to understand that. But the problem is that a lot of the not adequately competent members appointed to the tribunal think that they're in a court, and the only question that matters is legality. And legality does matter, but most cases hinge on whether the facts have been correctly understood, whether policy and other discretions have been correctly exercised. So first of all, the person needs the professional quality of being able to understand that it's administrative review that you and that it's an inquisitorial process where the tribunal needs to bring out all the facts that matter to making that correct and preferable decision, and do that without any partiality or value preferences. There's a piece in the Social Security Review from earlier this year that people can read on that if they want to follow that further. So what is my concern about the fitness for purpose of the Child Support and Social Services Division in particular? That was the one that I always served on, or Tier 1 Social Security Review. Well, it's that there is a lack of integrity and that there's political favour in member appointments. To be fair, there always has been in the past, to a small degree, 2 to 5% perhaps of members came from particular backgrounds that were favourable to the affiliation of the government in power. But as I think many of you already know, that in the last 3 years or so rose to 40% of all members. There's a lack of integrity and political favour. Why has that come about? Because the AAT has really never had an adequate, a totally adequate gold standard protocol about advertising for assessing people's potential and abilities for appointment to this tribunal. It's been treated too much as a potential to reward or pay back political favours and so on. And in recent times, there has essentially been a complete lack of any protocol or adherence to the weak protocol that did exist. So there were a lot of people who, when questions were put in Parliament on notice, the answers would come back to well, how many did these people apply for appointment? And very high percentages of people didn't even apply to join the tribunal. If they did apply, did they go through an interview panel? Again, very high proportions in recent times haven't even been interviewed to test their understanding of, do you know this is merits review, not sitting on courts. I've had personal conversations with very senior people on the general division who would say things like, "Oh, look, in a social security matter, I just won't listen to anything that isn't actually mentioned in the application by the person for review." Well, the person's got no idea about the law or the policy. They just they believe that a wrong decision has been made. So that's that kind of pleading, limiting things to the pleadings mindset. And, this was somebody who'd been deciding cases for a number of years at a very senior level. The Grattan Institute's done work over recent times about the rising proportion that I've already alluded to. I've given a reference there to a nice piece by Katina Curtis back in May of this year from the Sydney Morning Herald about that work. And what I've just brought up onto this slide, as you can see, is that some work was done by Professor Daniel Gieselbash and his colleague when he was at Macquarie University. They looked at what was happening in the refugee division, migration refugee division, and surprise, surprise, not a surprise, there was a really, really strong correlation between political background and likelihood of success. Likelihood of success of people who were deciding at least 50 cases where the two people being compared had a similar composition in their 50 cases as best could be achieved. And, success rates of refugee claims were from 90% down to, none or very small single digits. There's a lot of discretion, well, not as much as there used to be or should be in Social Security these days, but one would expect that in any of the discretionary areas in Social Security, a similar kind of study would find the same sort of correlation. That was talked about actually in Katina Curtis's piece in the May Sydney Morning Herald item. But you'll see that I've actually dug out from the ABC Law Report the link to chapter and verse, really, of what I've just said and a lot more about how robust or not is the methodology that they undertook and so on. It's worth, if you're going to read anything on that, then the piece in the ABC Law Report is the one to have a look at. It was also picked up by Mike Seacombe in the Saturday paper. So what is more important is it mainly a concern about capacity or about inappropriate backgrounds of appointees. I made a submission to the Senate Legal and Constitutional Affairs Committee that raised these concerns, and it's reflected in the final report, of course, that was handed down a few months ago. My view is that political background in and of itself is not the main concern. It is a concern, but it's not the main concern. Some great members who make excellent decisions have come from any and all political party backgrounds. It's rather that the problem is inadequate screening of the capacity of member appointments, not only for their technical competence, but as I talked about in the submission and in other stuff I've written, about their empathy and what I call tribunal side manner. I didn't invent that phrase. People use the bedside manner notion of, a good medical practitioner in terms of the kind of relationship that matters on the part of members. And there should be screening for all of those attributes, and it's the lack of those attributes that accounts for the problem. I also have written about in the Senate submission and in the Social Security report, etc., pieces about the Cullinan report into the amalgamation of the AAT, which included, of course, Social Security coming on board. And Cullinan, as I'm sure you know, was a former High Court judge, and with all respect to former High Court judges, he wouldn't meet the cut on any rigorous selection process for appointment to a merits review tribunal, at least on the basis of that report. I mean, it said silly things like that only lawyers are capable of making just, fair, appropriate, and empathetic. He didn't talk about empathy, but he should have. Decisions on a tribunal like this, and look, frankly, with respect to my profession and my own background, often we ought to be last cab off the rank. We're sometimes, or quite often, perhaps least likely to have the qualities that are required. So, and it's very unfortunate because a lot of media commentators, assess what's going on in the AAT at the moment by whether everybody has a legal background. Well, God help us if that's the only integrity and capacity change that's made to take off all the non-lawyers and ensure that everybody who replaces them is a lawyer. The tribunal would go further backwards, is my short point. It would not at all be a step forward. So, as I say, that tribunal side, or however you want to put it, ability to relate to applicants of members, that is critical. It's critical at at AAT 1 level. Because the time available for the hearing is so short. So people have to have that ability to read people's, emotions and body language and quickly, switch to the things that matter, as distinct from what appeared to matter when you were looking at the papers prior to a hearing. And I've talked about that in the Senate. You'll get a link to that if you want to look at that, or you can just have a look at that same Social Security rights review piece, short piece. So what should be done? Well, this is what the Senate Legal and Constitutional Affairs Committee thought should be done, that there should be a proper selection process, and they set out all of those dot points that people can look at later if need be, but that everybody should go through a rigorous selection process, and that there should be post-appointment, there should be reviews of performance, and that everybody should be on the same fixed length of appointment. One of the issues at the moment is that a lot of people in those 40% of partisan, on the face of it, appointments over the last 3 or 4 years, a lot of those people are on 5 or 7 year duration statutory appointments. And to what I say about the standard is, to me, it's self-evidently an essential minimum. You might want to improve on it further, but I think that's a hell of a good start. And be interested in what people think about that. And then finally, for me, under this title, the AAT to continue to be or not to be, that's because in paragraph 56, 7.56, the Senate committee recommended that because of the kinds of problems that I've been trying to allude to quickly, that we should start afresh, and that the current AAT should be statutorily abolished, like the cashless welfare card. It should have been abolished, decades ago, and that a complete clean slate, fresh start should be undertaken. And we know from the Katrina Curtis piece in June, I've given the reference there in Sydney Morning Herald, that it's a live-ish, I say a live, maybe live-ish is putting it more accurately, consideration within government, or at least it was still, as of the 29th of June of this year. And for the, I think everybody listening would appreciate that, you know, there's a paradox here that if you were to do as the Senate committee recommended, there would be significant sections of public opinion who would say, this is even worse than stacking the tribunal in the first place. You know, a new government abolishing the tribunal in order to, you know, the inference being make it more favourable to the incoming government than the outgoing government. So it's a really delicate balance. The problems are very, very serious. I mean, I don't want to understate the force of the concerns that I have, that the Senate committee had, that lots of people have had. But working out, you know, what as an Attorney General, incoming Attorney General, Dreyfus should be doing is a little bit easier said than done. And that's the finish for me. Why does it matter? Well, it matters mainly because of the impact that these things are having on actual cases of actual people at the actual present time. And Dermott Williams, who was know from you, the outline of the conference, is a community lawyer at Integrated Services Program at Social Security Rights Victoria. Now has the floor. We'll take questions later, but it could, you know, as a conversation. And as I say, I was just a warm-up act. And here's the background slide for Dermott, to whom I can hand over and turn off my microphone.
Thanks, Terry. You are definitely not the warm-up act. I feel like I'm the support act on this one. Thanks for that. It's very informative. It's always great to hear you speak. What I would like to do for my portion of this presentation is just talk to a few case studies that I've prepared. I always feel a bit overwhelmed with these kind of presentations about what I can actually contribute. And I think the big thing that I can contribute as a community lawyer working in this space is, as you say, Terry, the client stories, what the impact is, and what the issues that we see on the ground are. I would just point out that in the context of potentially the AAT being scrapped and being replaced with something else, these kind of issues that we see are the kind of things that we think, or I in particular think, should be considered when designing a new system. So not all of them relate to political appointments, capacity of members, though those are obviously very important things. But there's also other issues just with the functioning of the tribunal itself. So getting stuck into it. First case study is Kelly. Kelly is an older lady. She's in her mid-80s. She has a number of Centrelink issues. They all seem to relate back to whether she was considered a member of a couple. And she has a Centrelink debt that has resulted from that consideration about whether she is in fact a member of a couple. We assisted Kelly with her appeal, one of her appeals. She actually has multiple matters ongoing. One of the appeals at the SSCSD in January this year. It's August, the end of August. Kelly still doesn't have a decision from the AAT. This might sound like a bit of an aberration, a bit of a one-off issue, and in some ways it is. My experience at the SSCSD is it's normally really good in terms of turnaround time. It's normally you get a decision within 14 days, except it's not a one-off, because we actually had another case around the same time that was heard in January, which took months to get a decision. And what that experience has taught us or shown us in helping these clients is that there is very little transparency around what actually happens with a decision at the AAT. We were in a situation with myself and another lawyer helping these clients were contacting the AAT weekly to get an update. And we basically got and continue to get for Kelly, no useful information. We're just told, yeah, no, the decision's still there. It's still pending. I can't tell you whether it's been worked on. I can't see anything in the system. The case manager will say something along the lines of, I can put a note in for the member, but I can't actually do anything to force a decision to be made. What we've also found is that there doesn't appear to be a mechanism built into the AAT legislation to do anything about this. There is technically a time limit for decisions to be communicated within 14 days of the decision being made. But from what we can tell, a decision hasn't been made. So there's no time limit running on these particular matters here. From the client perspective, both of the clients that were affected by this, including Callie, were quite anxious. They were quite worried about doing anything to agitate for a decision and quite reluctant to do that. They felt that if they were to push too hard, they're going to get an adverse decision. They actually felt that being a pest, so to speak, would actually result in getting a decision that's unfavourable. Obviously, that's not what should happen. We would hope that the tribunal is making decisions on the merit and on the merit alone. But the fact that these people, these vulnerable people, are worried about that is very, very telling. I would also point out that we don't feel that the objectives of the tribunal, the legislative objectives from, I think it's section 2 or section 4, I forget, are being met in these particular cases. In particular, it's difficult to say that this has been a quick or accessible process. And these practices certainly don't promote trust and confidence in the AAT. The next case study I'd like to talk about is Tim. Tim is living with end-stage renal failure. He's on dialysis 3 days a week and is on a waiting list for a kidney transplant. He was rejected for the disability support pension because his conditions are not considered fully diagnosed, treated, and stabilised. The actual legal issue for Tim was a little bit complex in how the DSP legislation should be applied to his particular case and what we think the correct and preferable decision was. I'm going to sidestep that because I could spend hours talking about DSP stuff. I'll say that the short version is Tim's matter turned on the quality of the medical evidence that he was able to obtain, and he had a lot of trouble obtaining quality medical evidence. He was being treated in a public renal unit, and his doctor changed frequently. It was basically they would rotate in and out of that unit. Whilst most of the doctors are supportive of his DSP application, they weren't able to give the quality evidence that he needed to support that application, either because they didn't have time or it wasn't within the capacity of their role, or because they lacked experience with the DSP and what is really required to get that across the line. Coming to the tribunal, we assisted Tim with his SSCSD application. We assisted him to try and gather that medical evidence as well. And what that necessitated was actually seeking multiple adjournments of the hearing. With the DSP, to get full back pay, there is a 13-week limitation period to appeal to the SSCSD. So Tim had to put the application in. He couldn't put this off and wait until he got the medical evidence. But then once the AAT process is running, the AAT is quite keen to run that process, to get it to hearing, to make a decision. We were able to get some adjournments, but there was pushback from the AAT. In the end, we had to go to hearing. We couldn't get any further adjournments. We ran our arguments as best we could, and we also sought during that hearing an opportunity to get further information to assist the tribunal in making a decision. That was turned down. The member basically said, I've got all the information I need. I'll make the decision once in front of me. If there is further information, you can always go to the general division. You've got appeal rights. You can just take it up at the next level. And I can't say this for certainty, but the vibe that I got working on this particular case was that it was coming up to the end of the calendar year and they wanted to get this particular case off their books. They didn't want to have it carrying over into the new year. They didn't want to give us any more time to try and get what was needed to make the correct and preferable decision. It ended up being an unfavourable decision. And unfortunately, Tim decided that he wasn't going to take it any further. He wasn't going to go to the general division. He was worn out. He was experiencing kidney failure. He did not have the energy to do that. So it does seem like a miscarriage of justice in that particular case, but unfortunately, there's nothing further that we can do for Tim for that one. I would also point out that this issue of decision makers not taking the time to gather the appropriate information they need to make a correct and preferable decision is not unique to the AAT. When we're talking about Social Security, this is one of my bigger gripes with Centrelink itself. Like in this particular case, Centrelink could have gone the extra mile. It shouldn't even be considered the extra mile, but they could have gone and helped Tim get the evidence to show that he's eligible for the DSP. And I think it's quite reasonable when you've got someone who is literally waiting for a transplant that may never come, to try and help it's the social security system. It's meant to help people. The next case study is Roger. Roger has a number of complex medical issues. He applied for the DSP in 2018. He was unsuccessful and pursued appeals as far as the general division of the AAT by himself, completely unrepresented, just pushing through on his own. We first spoke to Roger when he was put in touch with our service in 2020, so already 2 years into this process. At the time we got involved, several conferences at the general division had already taken place, and the AAT was basically awaiting submissions, which were due early 2021, for each of the parties before setting up a hearing. We took on the case, we opened the file, and we assisted Roger in preparing these and then lodged them at the tribunal. I think it was a day before the respondents, before Centrelink submissions were due, we actually got an email and I think a phone call as well saying, hey, we'd like to settle this one. We'd like to just give Roger the DSP. We're not going to go to hearing. That was obviously a great outcome for Roger. And while I'm not obviously privy to the other side's reasoning for why they decided they didn't want to fight this one, I'm going to take credit and say it was the great submissions that I did. But I think what's really telling about this one is this happened early 2021, almost a year to the day that Roger had applied for the DSP. So it's 3 years that he's had to fight this, only for someone representing Centrelink to turn around and go, oh, now that we've looked at it, actually, we should have put you on that. That's 3 years of essentially trauma that Roger's being put through. 3 years of fighting for something that they're entitled to all along. While there are always going to be cases where having a lawyer, and this one is an example of this, is valuable to set things out, to do submissions, to tell the story for the client. And that's the role that we play and the role that we're really proud to play. While there's always going to be cases where that is necessary, the sheer number of self-represented people at the tribunal who don't have access to us and cannot get access to us because there is not enough of us, it just begs the question, how many people are getting unfavorable, unjust, incorrect, not preferable decisions from the tribunal, not based on the merit of their matter, but just because they don't have access to the support they need. I'd raise this as a point for 2 reasons. One, like I said earlier, if we're having a conversation about redesigning the tribunal, then these are the kind of things that we need to keep in mind. We need to make sure that the tribunal is accessible for people who cannot get this kind of support. That does work for self-represented litigants if we're going to have self-represented litigants. But that's only one side of the conversation. The other side of the conversation is that services like ours, like Social Security Rights Victoria and all the other welfare rights services around Australia, are essentially an integral part of the administrative review system. And we need to be able to, do more of this work because, like I say, some of these matters require a lawyer or another advocate to step in and set out this process, to set out the story, to tell the client's story and help them advocate for themselves. I mentioned that it was traumatic for this person, for Roger. It was 3 years of trauma. He told me that his medical conditions, and in particular his anxiety and depression, are much, much worse than they were when he applied for the DSP. So he'd already had conditions severe enough to get him the disability support pension. That's what the ultimate outcome was. But they've actively been made worse by this process. The last case study that I'd like to talk to is Tony. Now, Tony, I would just preface this by saying that this is actually a positive outcome. So it's not all doom and gloom, and I have a reason for bringing up a positive one here. Tony came to us with a Centrelink debt caused by errors in reporting her income. Tony's on the DSP and is living with an intellectual disability. She has a small capacity for work, and she does like to use that capacity because, works great, works fulfilling for her in particular. But things like reporting income are difficult to get right. So understandably, mistakes happen. Tony lives in rural Victoria, and she was actually affected by the Black Summer bushfires. And I don't just mean she was in the area. I mean, she and her mother had to flee the fires in East Gippsland while under Ember attack. They came through with only minor injuries. I think there was some smoke inhalation from memory. But their car was so severely affected by the actual fires, by the Ember attacks, that when they came across the hills and got to safety, they had to pull into a mechanic, and basically the mechanic popped the bonnet and immediately used a fire extinguisher. on it, because that's how severe the damage was. And then the car was a write-off, basically. I mention that because I want to highlight how traumatic the situation Tony was in was. There's a few other things that I won't go into, other than to say that Tony was also a victim of family violence, and that family violence, the way that that was perpetrated, without getting into the gory details, involved fire. So being affected by fires was obviously a traumatic weak point for this person. We came on board, we saw that this is an incredibly vulnerable person, and we helped Tony run her debt waiver application at the SSCSD based entirely on special circumstances. That was successful. But what really stood out to me is that this was the tribunal working at its best. The member was incredibly empathetic, was asking the right questions, was giving Tony time after the hearing to go and get further documents which would make the decision to waive the debt more solid, was open to ideas about just waiving the debt going forward so that recovery stops, which was Tony's biggest issue, rather than trying to waive the debt that has been recovered retrospectively and get a refund. That wasn't an issue. It was flexible. It's all the things that Terry has said with tribunal side manner. It was a really good experience, as good experience as someone who's appealing a Centrelink decision can have, I guess, at the tribunal. It's not to say that the member was on Tony's side, but rather took the role of stepping into Centrelink's shoes and making the correct and preferable decision seriously, and made sure that this member had the information she needed to make that decision. And the reason I bring this up is because I think that if we're talking about what the tribunal should look like, what the administrative review system should look like, this is the example of it. This is where it works. This is where we get good outcomes. And these are the kinds of people that we need to keep in mind when we're designing the system. So those are my 4 case studies. I realize we've got a lot of time left. I think it might be question time.
Thank you, Dermott and Terry. Far from being the sideshow, Dermott, I think having those case studies really brings to vivid mind the impact of administrative decision making on real people. And with that in mind, I've got a first question. I was practicing in this area long ago enough to have represented clients at the Social Security Appeals Tribunal, and the kinds of case studies that you've explained in this session demonstrate, I think, the need for an accessible, informal forum in which people can go, especially if they're unrepresented, because most people won't actually make it to Economic Justice Australia's member centres for legal help. I was just wondering, Terry and Dermott, what you think about if we do have the opportunity to rebuild the tribunal, whether we need to look at re-including that first level.
Yes, the on the need for two tiers of appeal in Social Security, I'm firm about that. I've been firm about that for the best part of 30 years. And it is because it is such a high volume of decisions made by the administration. It means that there is always going to be a lot of appeals that need to be dealt with on review. And most of those ought to be capable of being dealt with in the hour or so of a hearing, if you've got a member who, like Dermott was saying, who runs a hearing the way that last case exemplified. So you need the human beings who are capable of providing that quality of experience. You also, though, and I didn't touch on it, and we haven't, you need you need not to have an efficiency dividend continuing to erode the resourcing of the tribunal. Even with the best member selection, at the moment there is too much pressure for example, for people to give oral reasons rather than the discipline of the written reasons. And the reason for that is just that, you know, the caseload keeps expanding in terms of the unresolved cases, and you know, you are quick and efficient and just are very important at tier 1, and you need yes, a budget that allows correct choices to be made about you know, how many. Somebody asked on the chat about you know, what I think of the move to single member hearings. You know, that's what, 10 years ago, whatever, a long time ago. That was because of lack of money. That was the principal driver of no longer having multi-member hearings. They were far, far superior. The ability of, whether you were presiding or not, of just being able to sit and listen to the conversation and butt in when you could see what the two parties speaking, you know, weren't really sort of getting across to each other. But that's lost. I mean, it's now just one person has to try to yeah, be doing that. So yeah, I strongly support the 2 tiers. The Callanan report got that totally wrong too. It indicates you know, how little background they had of this kind of jurisdiction, and yeah, the money question mattered.
I'll just briefly add. I personally find a lot of value in the SSCSD. I do think that the informal nature of that, even working as a lawyer, can be quite easy to engage with. But I would like to acknowledge that some of my colleagues disagree with me on that. And they say that there are some problems with the SSCSD. One that I would particularly point out with debt matters is there's very little opportunity for Centrelink to actually try and settle a debt matter at the SSCSD because they're not represented. You don't have the lawyer there who's looking for the compromise. Where debt matters are settled by compromise, it is always at the general division. So sometimes you realise as a lawyer that the matter is not actually going to be successful at the SSCSD and it's going to have to get to the general division before the lawyer on the other side can come to the table.
Thank you. And I'm going to now turn to a question that Terry's already answered in the Q&A, but I think everyone will want to hear the answer. So, Terry, how does automated decision-making affect AAT members' capacity to review cases? Are AAT members kept sufficiently abreast of automated decision-making, for example, in applying mutual obligation penalties?
Yeah, well, it's becoming more challenging, and Paul Henman, my colleague, is going to talk about that in his session, I guess. And I've written 2 or 3 papers more on the automation, the artificial intelligence side. But look, so far as the tribunal hearings are concerned, for 20, 30 years, nearly all the time I was on the tribunal, it was sort of fully turned into computer jargon. The papers are a dump of what comes off really one of the Commonwealth's oldest information management systems. So it's, you know, full of acronyms and unintelligible, and yes, it's a challenge for everybody, but particularly the tribunal member, if the person is, as they usually are, totally unrepresented, to wade through what can be, you know, 1,000 pages in a debt matter, to find the particular abbreviated note of a conversation that, you know, vindicates what they're saying, and so on. So the tribunal, the old one and the new one, the SSAT and the AAT. Tier 1 have always been dealing with automation. Robo-debt obviously, you know, exacerbated that, and you know, to be honest, nobody picked it up, and that actually includes welfare rights. And I understand why welfare rights didn't ever fully get to grips with the illegality question, for instance. So those challenges are going to be greater, and they're certainly greater under whatever it's now called Workforce Australia that Paul is going to be talking about and that he and I write about. So,
thank you, Terry. The next question is for Dermott from Chris Stone at Suicide Prevention Australia. What do you think led to the better process in your final case study? What factors meant that the member did their job well? And how can we make sure this happens all the time?
That's a really good question, Chris. I'm tempted to say that the member was just higher quality because I don't think that there's anything that we did to approach that particular file or case differently than we would with anyone else. But to give the context of what we did do, we basically set out written submissions, setting out the entire legal issue, covering everything that we wanted to cover, what the law is, how the law should be applied, how it applies to these particular set of facts. So all that sort of standard lawyer stuff, basically. I do feel like that member had an understanding of the scenario and the situation before coming into the hearing. So it was very focused on particular things the member wanted to know and particular things the member wanted to expand on. And there wasn't the need to tell the story from scratch. But it's difficult for me to say, and maybe this is me being a lawyer and being allergic to certainty, but it's difficult to say that that's what was making the difference for that particular client.
I'd agree as a member for all that time. Assembling as a member the narrative, the story, was the main focus and challenge if you're unaided. And so and that's why welfare rights was always far superior to, lawyers that are rolled in, out from some firm. It is being provided, even in a half page or a page with the story, the narrative, getting the narrative sorted out.
The next question is from Chris Belcher from Welfare Rights and Advocacy Service in Perth. Do you think that the centralisation of the tribunal administration has impacted on the ability for self-represented clients to obtain a fair hearing? For example, booking a hearing time, obtaining papers in a relevant time, etc.
I might just quickly add to that one, respond to that one and say it's difficult for me to say because I haven't noticed. I mean, I've only been practicing as a lawyer since 2020, and I've only been involved with Social Security legal stuff since 2017 in different capacities. I haven't noticed a difference in that time, but I feel like, Terry, you might have some thoughts going a little bit further back.
The great boon and benefit of AAT amalgamation was that you got centralised administration and support. There were some retrograde things that happened as that division's Social Security and Child Support division was, harmonised with other divisions. Sometimes there were steps backwards. But for example, to give one practical example, in the old days, pre-amalgamation, you did, as the member, in your 1 hour per case, and you had 3 cases in your session, and there's a limit to how long you can, just stay around in that hearing room because somebody else is going to come in the next session. You did all of your own photocopying. There was not a capacity until AAT amalgamation to pick up the phone and have an admin person come in, collect the, often several hundred pages of originals that needed to go, that the applicant wanted back. Understandably, it's the only copy they had of some documents. You had to try to do that at the same time as conduct your hearing. So there were a number of, I think, significant improvements. There should be a lot more. There should be the case conferencing and other things that the General Division has extended to it. But, yeah.
The next question is from an anonymous audience member. Is Centrelink complying with its model litigant obligations? Is there a role for Centrelink, not just the tribunals, in better allowing self-represented litigants to properly advance their case?
I think that's a super interesting question. Sorry, I have a lot of thoughts about model litigant stuff. I will stop short of saying that they're not complying with the model litigant obligations, but I have concerns when a matter gets to the General Division, and particularly with non-government lawyers, so when they brief a firm from outside. Sometimes the practices that they engage in my experience, I'm talking to my own experience just to be very clear here, I do feel like they're towing the line. They're pushing the boundary of behaving as a model litigant. And so having concerns about that, I think, is incredibly fair. If the question about Centrelink themselves, more engaging with that, as in at the Centrelink level before it gets to the tribunal, I think some people would say that it's not litigation at that point, so they don't have to do model litigant stuff. I don't necessarily buy that myself. I think that they should be behaving as model litigants at all steps in this process. And whether they're falling short of model litigant obligations now or not, there's definitely improvements that they could make. One example, and for context, the DSP, the Disability Support Pension, has been a key project of mine. We have the DSP Help Project at SSRV for the last 2 years, so kind of all in the DSP space for me. One issue with that, or one area that they could improve, would be helping clients get medical evidence to support their application. I feel like that would be closer to a model litigant than what we have at the moment.
Short answer is no, neither Centrelink nor at the tribunal is the model litigant protocol applied at all, I'd have to say. They don't regard it as relevant. The Robodebt example, a classic of that. And my view today is not a new view. It's one of the 7 veils, the 7 great sins, failures of administrative review and ombudsman and everything else that, I wrote about in the Alternative Law Journal piece, the 7 veils piece a couple of years ago.
The next question is from the Welfare Rights Centre, and brace yourselves because it is a long one. So the Welfare Rights Centre says, we recently had a matter where the Social Security and Child Support Division member adjourned a hearing for an unrepresented applicant in order to ask Centrelink to gather new medical evidence and to encourage the applicant to get representation. The applicant came to the Welfare Rights Centre. The AAT directed Centrelink to request medical evidence from very specific medical institutions. Centrelink provided a further 6 pages of documents. We sought evidence from the same medical institution and provided over 100 pages of new documents in support of the applicant's claim. The applicant was ultimately successful in their application based on the new evidence. How can the AAT come to the correct and preferable decisions if it is not making decisions based on all the relevant evidence?
I'll say a word or two about that. In that case, that's brilliant, and that should be routine. The tribunal shouldn't need to issue directions to have that material collected. But more often than not, in the vast majority of DSPs that I experienced, the later evidence is about a deterioration. And although later evidence can, in some circumstances, reflect on satisfaction of the eligibility requirement in the 13 weeks after the claim, if it is only addressing something on week 14, 15 or later, and very often it is because, a year or so has gone down, too long has transpired from the actual application to getting to the tribunal, there is nothing that the tribunal can do. You must be found to be eligible on all the counts in the 13-week period. So often the most useful thing that a tribunal could do was quickly, establish which of the criteria was satisfied in the 13 weeks of the previous application, provide the person with the full text, because most of their medical practitioners would never have seen the rating instrument, provide them with the relevant tables that applied to their conditions and the scores they are currently getting, and have them in a position to lodge a fresh and successful application very, very quickly.
I'd add on to that and say that I don't believe this is possible. I would need to look at the specific provisions because it's a little bit complex, but I think one idea for solving that issue would be to allow a deemed claim where the tribunal has found that a person is eligible now, but they weren't eligible during the qualification period, to eliminate the need for the person to then apply again.
Yes.
One of the big frustrating things that we see is that they then have to go back to their doctors, get their updated medical evidence, and the doctors at this point are frustrated. They don't want to do it. They don't want to engage. And so they're still on the merry-go-round. To answer the original question that was posed there, it's like, how can the AAT make these decisions if they don't have all the information? I would just say, well, if they don't have all the information, then they probably can't. But I think that was really the point of the question. It was more a comment. But it's a good comment.
Yeah, the legal obligation is that, you know, you have to make a decision if no further information is capable of being obtained. You can have all the adjournments, but at the end of the day, you've just got to make it on whatever the inadequate state of them. Yeah, it's not good. And you're right, Dermott, there are a whole lot of changes that we talk about, particularly to meet AI, but to deal with a lot of other pressures that the procedure of the first tier tribunal could be changed in a lot of regards. And that's a good suggestion that you mentioned, one that I would support.
Well, that's the end of our questions. I think we've answered all of the audience questions. So any final words from you, Terry or Dermott, before we wrap up? Let's see, shaking. Well, please.
Good luck with the lobbying to get the changes that are needed.
And thanks for having us.
And thanks for having us, yes, indeed. Yeah.
Thank you very much, Terry and Dermott, for a really fascinating and insightful discussion.